and one relating to the scope of the determination under paragraph 25
Yes,
of the same Act.
yes. And there's a respondent's notice as well.
Indeed. Yes.
Yes.
Before I begin, do you have our skeletons
Yes.
and 3 bundles of core, supplementary and authoritative bundles?
Yes, for some reason I never got the physical bundles, but I've got them electronically. I think the Lords have got them physically.
Yes, I've got physical bundles.
The
authorities bundle was so overstuffed, I've put it into 2 files.
I have two.
I apologise for that.
And Mr. Birkbeck, you've got to win on both points, haven't you?
I do, yes.
And you can be confident, because it's true, that we've not only got the skeletons, but we've read them. We've read quite obviously the underlying decisions, and certainly for my part of the legislation, I haven't gone into the cases, but the laws maybe are more familiar with them. But you start with a high level of knowledge about the points that you wish to raise.
I'm grateful, my Lord, because in the Upper Tribunal we were very much pressed for time dealing with essentially the same points, and in fact ground 2 had to be determined on the papers in the end. So I'm hoping to be able to get through this quick enough to get onto my submissions on ground 2 today.
Yes.
And so with that in mind, my proposal is to deal with the background legislation very briefly. If you'd prefer, I can effectively skip over the facts and the broad scheme of Section 45, if you'd like me to. But otherwise, I'll deal with those very quickly.
Well, I think for my part, there's no need to go to the background facts.
No, I mean, the facts are found.
Yeah, we have an ABC transaction.
They're very straightforward.
A vendor, a company,
Yes.
and a distribution out, share subscription. They are set out in my skeleton,
Yes.
and really they're agreed and not in dispute today. Equally, the scheme of Section 45 and the way it provides relief for subsales and assignments it is broadly, I take it, at read today. And obviously, I'll be coming to it in some detail as I go forwards. But so with that initial preamble dealt with, then my submissions today are going to be broadly into 3 parts. Firstly, I think it would be appropriate if you're in agreement to deal with the connected party limb issue first. That's the respondent's notice. They seek to put a new ground to you today.
That's not dealt with in your skeleton.
It is not. It is dealt with in the Upper Tribunal skeleton, which is in the bundle, but no, it's not. But the point is a simple one.
Yeah.
I hope to be brief on that.
And it's agreed that Mr. and Mrs. Brown are connected with Earlswood.
It is, yes, with the company, yes. Then I'll move on to ground 1, i.e. the interpretation of Section 45(3). That, I imagine, will be the most complex and substantial issue to get into today. I hope to spend an hour and a half or so on it, which will hopefully leave me 30 to 45 minutes for ground 2 and the issue on the determination. I imagine that will be briefer. Hopefully that will get me done by lunch or shortly afterwards.
Just picking up on ground 2 for a moment, it doesn't seem to be seriously disputed that at any rate potentially Section 75A applies. Your point is effectively a procedural one, which is that the determination was made on the wrong basis.
That's correct. There's no appeal against the finding that if Section 45 doesn't impose a charge, Section 75A does. And therefore, there would be a liability under Section 75A. The only question is how it was assessed by the determination and whether that determination covered the notional transaction under 75A, as well as the secondary contract transaction under Section 45. So, before I go any further with those, one thing probably needs to be made clear, that I'm not here today to convince you that the scheme sold to Mr. and Mrs. Brown back in 2011 worked. It clearly didn't, for two reasons. Firstly, the connected party limb of Section 45(3)(b)(1 must be an application here. Now there are some problems that have been identified in previous cases with the connected party limb, in that it can produce double taxation in a situation, not this one, but in others. But I think it's clear that that connected party argument must be effective, and this scheme doesn't work. Why that was missed in the diversion of the scheme, or whether it was simply that those devising it were aware that HMRC didn't take the point and didn't assess on that basis, I can't tell you. But I'm not here to tell you that aspect of Section 45(3)(b)(1) isn't engaged today.
And how do you succeed on ground 1?
Well, simply so, on the procedural point.
No, that's ground 2.
Well,
Section 75A.
The connected party issue is itself a procedural point, my lord. This ground was only raised at the Upper Tribunal for the first time.
Right.
The Upper Tribunal declined to allow that ground to be put, a new point on appeal to be raised.
Oh, did they?
And they are essentially applying for this new point to be put again to you today.
And it hasn't been argued yet.
No, it hasn't been
in this
argued.
case. Yeah.
So,
And it hasn't been argued ever before,
Right.
because for 10 years HMRC have not taken the point.
Because they haven't needed to.
For some policy reason,
And therefore
they've
they-
decided as a matter of policy they don't want to argue against subsidy schemes on the basis of connected
so is
parties.
there a ruling then by the Upper Tribunal refusing to allow the point to be taken?
Yes, there is, my lord.
Right.
It is, I can take you to it, it is at paragraph 73
Right.
on page 78 of the core bundle. We've come to this conclusion, that is in respect of the liability in section 45, without needing to consider HMRC's other alternative argument, namely the connected person argument, as some
Yes,
might
I
say.
did read that. I didn't take that as a refusal. I took it as saying, well, we don't really need to decide this.
The last sentence there reads,
Yeah,
although the
yeah.
point is a pure point of law and we have the discretion to permit HMRC to raise the argument provided, we are satisfied that there will be no prejudice and to Mr. Brisbane doing so. As it is not necessary to deal with the point in our conclusion, we decline to do so, i.e. we decline to admit the point.
Just for my note, a short time ago you said the scheme plainly didn't work because of two reasons. One was the connected party limb must apply. Did you say what the second?
No, I didn't get to that, my lord.
Yeah.
The second is section 75A,
Yeah.
which if section 45 does not create a charge, then section 75A does. That was the finding of the first tier tribunal, not appealed.
Okay. Thank you.
So HMRC again today raised this new point. Now they don't do so on the basis they're challenging the decision of the Upper Tribunal, paragraph 73, as an error of law. Clearly that would be wrong anyway. The Upper Tribunal there exercises discretion not to allow a point, and there's no challenge to the exercise of that discretion. Essentially, HMRC are seeking to raise that connected party argument as a new point at this stage in the appeal. Again, my learned friend wants to intervene.
Yes, Mr.
Just to
Reddy.
make sure that we're sort of clear on what the parties' positions, if that might help the cause.
Yes, it would be
Let's
helpful.
say our reading of that paragraph had been that the declining relates to the dealing with the point in that sentence. So it might be helpful if we knew what this procedure. We agree that there is a procedural argument here, but our interpretation had been, as I believe Lord Justice Lewison, your starting point had been, that the Upper Tribunal had said we're not deciding whether or not to grant permission, so that this court would be the first court deciding that.
Right.
And whether I'm right or not on that, it might
So
be helpful if we
was
set
the
out our
connected
position.
person's point argued before the Upper Tribunal?
Yes, it was.
So they didn't decline, they didn't refuse you
Well-
permission
Well,
to raise
they
it?
had it to Beni Esse,
Yeah.
in fairness. I think we do have a different interpretation. I do see my learned friend's
no,
interpretation
so
of that
do
sentence.
both.
I think we do have a difference in interpretation of that, quite an important one, potentially, given my learned friend's concession in relation to that sentence.
Very well, thank you.
I'm grateful to my learned friend for that clarification. But perhaps in the end, it makes no difference in the sense that obviously the Lordship still have discretion to admit a new point of law. And I certainly can't say with any authority that the Upper Tribunal's refusal to allow a new point of law binds you. to the same outcome. Which is why we must look to the law on allowing a new point of law on appeal. And on that, the authority is Notting Hill Finance versus Shake, which you can find on page 145 of the authorities bundle.
Would you like us to look at that?
I would, my lord. Particularly paragraphs 21 onwards, where there is a succinct summary of the principles. And there, Mr. Justice Snowden at 21 sets out how courts approach allowing a new point to be raised on appeal. And the starting point, of course, there's no dispute that an appellate court has a general discretion whether to allow points to be taken on appeal. The question is how that should be exercised. And in paragraph 23, the court quotes Lord Justice Norse in the Petalis and Grant case. The stance which an appellate court should take towards a point not raised that trial is in general well settled is perhaps best stated in Ex parte Firth in Re Calburn. The rule is that if a point was not taken before the tribunal which hears the evidence, and the evidence could have been adduced which by any possibility would prevent the point from succeeding, it cannot be taken afterwards. You're bound to take the point at first instance so as to enable the other party to give evidence. That clearly, obviously, is not relevant today, given there's no evidential issues. But even if the point is a pure point of law, the appellate court retains its discretion to exclude it. So that's the discretion I'm asking you to exercise today. Where we can be confident, first, the other party has an opportunity enough to meet it. We have. I don't claim that one. Secondly, that he's not acted to his detriment on the faith of the early admission to raise it. That, I say, the appellant here has acted to his detriment. And thirdly, that he can be adequately protected in costs. Our usual practice is to allow a pure point of law not raised below to be taken to this court. Otherwise, in the name of doing justice to the other party, we might, through visiting the sins of the advisor on the client, do an injustice to the party who seeks to raise it. And that principle is then sort of re-articulated in the paragraph from Singh and Das in paragraph 25.
And then we've got this spectrum in 27 and 28, and we're at the 28 end of the spectrum. Indeed,
yes. Yeah, we are a pure point of law. So the question is, should you exercise your discretion to allow it on that basis? And whilst the general rule is that on a pure point of law like this, you'd be expected to do so, this is not a general or usual situation. This is an exceptional instance of a new point of law being raised on appeal. And the reason for that is simply that this is not a case where HMRC missed the point at first instance. It's not a case where they weren't aware of it or their legal advice didn't cover the point and they failed in their arguments to put a compelling legal argument. They chose not to run this argument. And they chose to do so, not just in this case, but for the last 10 to 12 years, certainly since Vardy. It's instructive perhaps to take you to Vardy.
We know from the fact that this was a marketed SDLT avoidance scheme. I'm guessing from the amount actually in issue that there are wider implications. Is that right?
I'm not sure if there are any cases following this one.
Oh, is that right?
I'm not aware of any. Certainly we didn't have any Rule 18 directions or anything like that. So no. I mean, clearly, obviously, there are wider implications as to the scope of Section 45 and how this argument can be run. But a finding today that HMRC should not be allowed to introduce a new point of appeal that they deliberately held back at first instance would not affect those other decisions anyway, because they say they don't follow automatically from this one.
Yeah. If I understood Mr. Elliott's contribution a short time ago, it was argued. It didn't hold back. It wasn't their primary submission, but it was raised before the Upper Tribunal. Is that
It was raised before the Upper Tribunal as a new point, and I put to the Upper Tribunal the same point I'm putting to you today, which is they shouldn't be allowed to raise it at the Upper Tribunal because they had held it back at first tier.
Yeah.
If the argument had been put at first tier, and in fact if it had been put during the investigation, it's highly doubtful whether the appellant would have resisted and gone to the trouble of disputing HMRC's interpretation of Section 45. Because, as I say,
because
it's very hard to argue against
part of your
party
concession
limit.
is that it does apply.
Well, it's very, very, very hard to argue against it. There are arguments against it, particularly in the sense, as I say, that it can lead to double taxation. In a situation, consider where there's a subsale for consideration to a spouse. So a husband pays full consideration and subsales to a spouse. In that case, you would have the spouse pays full consideration under 45B(3)(2). Husband pays full consideration under B1. You add them up and charge the wife to double taxation, double the amount under. So there are situations where you think, well, implying the connected party limit could lead to punitive outcomes. But that's not to say it doesn't apply. And certainly not in this case. So the decision not to run this argument is strange. And I'm afraid I can't help you with that. Perhaps my learned friend can. But it's clear it was a policy decision. And as I said, I'd like to take you to Vardy.
Yes.
On
8, is it?
It's 230, the authorities bundle. Is the case, and the relevant paragraphs are on page 246, paragraph 72(4), paragraph 4. At first sight, a further apparent difficulty arose from Mr. Quinlan because VP and VPT were admittedly connected within the meaning of the relevant act at all material times. And then it sets out the facts. A bit further down, Mr. Quinlan argued that this was not correct due to the specific words is to be given in section 45(3)(b)(1). The use of those words, so this is the taxpayers' counsel here, the use of those words implied that the question of what consideration is to be given should be tested by reference to the secondary contract when it comes to its existence. Only consideration that was required to be given under that contract should be brought into account. In this case, of course, the notional secondary contract was the declaration of the dividend, under which VPT was not required to give any consideration. Ms. McCarthy accepted this argument, acknowledging that otherwise the connected person element of section 45(3)(b)(1) would accidentally catch many perfectly normal situations which the general policy of section 45(3) as a whole did not intend to cover. So there we are back in 2012, HMRC refusing and holding back on this connected party limit. So,
but you would expect, would you not, the FTT to follow a previous decision of the FTT? It may not be strictly bound to do so, but in practice that's what it will do.
Often, yes.
So the first real chance that HMRC have to run the argument is in the Upper Tribunal.
Well, again, if we turn to the first tier decision in this matter, paragraph 62 on page 113 of the core bundle, we see that the FTT did consider this argument.
Oh, just there. FTT paragraph?
62.
Yes.
The second issue is a reference to 3B1 to a person connected with C. In Varley, those words were read literally. Were considered to give rise to an anomaly in perfectly normal situations which the general policy of section 45(3) did not intend to cover, considered by HMRC, that is, in the passage I've just referred you to. And it was accepted on all sides that what was to be given should be tested by reading into this paragraph under the terms of the transfer of rights, after the words directly and indirectly. I find it difficult, paragraph 63, to understand why considerations of policy should require the use of additional words where their addition could produce an enormous advantage, where, for example, B is connected to C, C procures that B pays A under the transfer of rights, and agrees to sell to C for £1. Further, in an ordinary sub-sale transaction, a well-advised party would take care to avoid a connection to be if possible. Lacunae can result in a relief being limited in scope as well as in no tax. The person indulging in tax planning arrangement cannot complain that the steps he takes results in more tax than less on a fair reading of the legislation. The words is to be given suggest to me not something to be given under limited provisions of the transfer of rights, but as consideration under the AB contract. In the instant appeal, the company was connected, so the consideration given by it under its purchase contract would, on a literal reading, fall within 3B1 as consideration given by a connected person. Thus, if I'm correct, my approach to 3B1 consideration of £955,000 would arise under the connected party limit of 3B1 in addition to any arising under 3B2. Mr. Street did not, however, wish to put HMRC's case on the basis of connection, and Mr. Burbeck argued that it would be anomalous to read the provisions literally, adopting their argument in party. That's all that's said on this point by the First Tier Tribunal. They, in a sense, accept that HMRC is not pursuing the case on the basis of the connected party argument and decline to apply it, despite having very serious reservations there about whether or not refusing to apply it is right. So as I say, the appellant went into the first hearing not being required to defend a connected party argument, in agreement with HMRC about how that should be approached. And the issue was how 45.3 operates absent that argument in this situation. And yet, on appeal to the Upper Tribunal, the point was raised as a substantive one and relied on. I asked the Upper Tribunal, as I'm asking you today, not to allow that new point to be raised today, essentially because it's an abusive process and certainly not in accordance with the overriding objective. It's one thing for a party to realise on appeal that they've missed an important point and have a chance to put it if that doesn't prejudice the giving of evidence below. It's entirely another for a litigant to keep in their back pocket points to later rely on in the appellate courts. That approach can only lead to escalating costs, delays, and procedural arguments, amongst others. But also it just undermines the process of the first instance. So I say this is an exceptional situation, the viewpoint being raised on appeal, a very exceptional situation. The fact that it's a public body perhaps raises even greater concerns. And I'm really in your hands on that. I have no more to say other than those submissions. It would be contrary to the overriding objective to allow this point today.
Is it also an aspect of the exceptionality, if there is exceptionality of the point, that you're effectively conceding that it's a good point?
Indeed, yes, because would this case have got as far as it had? Certainly would it have got to the Upper Tribunal if it had been put by HMRC from the beginning.
So if you put that before us as an argument in your favour, because you're saying they've deliberately not taken what might have been an on-target point.
They should have taken it in 2012 in Vardy and got a decision on that point, which would have given us some law to go on. But instead, for 10 years, they pursued my client, as well as perhaps many others, on the basis of a different application of Section 45. And essentially, they say, let us up the garden path. And not only has
allowed you to go up the garden.
Allowed to go up the garden, but also in the process, in accommodating HMRC's refusal to run that argument, the tribunals below have made bad law, and that's fundamentally my submission on ground one. Because they, on the encouragement of HMRC, didn't have recourse to the connected party limit 45.3b1, they've been forced, in order to make Section 45 work in the way they felt it should, i.e. this scheme shouldn't work, contorted the law and expanded it to a point where it's uncertain, difficult to operate in certain circumstances. And in short, it's bad law where we are now. That's why we're here on appeal, obviously. So the consequences, not just for this case, we're left in a mess as a result of this. Again, it's the kind of behaviour that should not be permissible and is contrary to the overriding objective.
Thank you. Do you want to hear any more on that? Mr. Birkbeck, we're very sympathetic and understanding of the submission you make about this, but there's a concern I think all three of us have that if you're right, that the connected persons point would represent a much crisper interpretation of the legislation, allow all parties to understand where they are, and for a decade tribunals and determinations have been made without that, then that's an argument we feel for letting the point in and having it considered and determined in the course of this appeal.
Well, as I say, ultimately, I'm in your hands as to whether or not you want to admit the point. My suggestion might be you might want to comment obiter on it, despite not deciding the case on that basis for the procedural reasons I've set out.
So how, on the basis that we would wish to hear argument about it, are you able to present submissions on the connected persons point, or is your point that it simply shouldn't be taken? And that's that?
My point is simply shouldn't be taken. Yeah. My point is, on a literal and precise reading of 53b1, the payment paid by the company, the consideration given under the original contract, i.e. what the company paid to the vendor, was given not by C, my client, but by a person connected with C, the company, and therefore falls to charge under that section. That's a straight and literal meaning of the words. And essentially my submissions on ground one are that this is very precise legislation that does what it says.
Right. Well, it is, unless either of my lords disagree, the connected persons point is raised in the respondent's notice, so it's the proper course is for Mr. Elliott to make his submissions about it and for you then to deal with it as you wish in reply. Yeah. That's probably the way to proceed. Yeah.
Perhaps my last point was were you to omit the argument and indeed decide against us on the basis of it, I would ask you to make a protective costs order in regards to this appeal, both today and at the Upper Tribunal.
Yes, well, that's one of the considerations that Lord Justice Norse mentioned in Patalis, that if you can be protected in costs, that's...
Indeed. I'm acting pro bono throughout this matter, so there's no issue on that from our side, but of course HMRC's costs would present a significant bill, and we feel that would be, if you're against me on admitting the point at all, certainly that would be a necessary part of the
Well, I think that's a legitimate submission to make. We've noted. So should we move on then to your substantive grounds?
I'm grateful, yes. So the starting point is the ratio of the Upper Tribunal. I've set that out of paragraph 10 of my skeleton. Paragraph 44 of the decision. And this follows, of course, a reasonably extensive quotation from Hurstwood, Rosendale and Hurstwood, the Supreme Court's leading judgment on interpretation of statutes in the tax context. At all.
Sorry, we're in your skeleton at
Paragraph 10.
Thank you.
And the decision of paragraph 44 as set out there. In our view, the proper construction of section 45 in the context of the scheme of legislation as a whole leads to the conclusion in this case, SDLT is chargeable in respect of the secondary contract that is deemed to occur by operation of section 45.3. And the chargeable consideration for that transaction is £955,000. In our view, that consideration arises under 45.3b1. That is because the sum is such consideration under the original contract. This £955,000, of course, is the share subscription value.
Yes.
That sum is such consideration under the original contract between the vendor and the company, as is referable to the subject matter of the secondary contract, which is provided indirectly by Mr. and Mrs. Brown.
The share subscription was, the total share subscription was the 960.
60, yes. Yeah. Forgive me, yes. So the amount provided by the company,
For the conveyance.
to the vendor,
Yeah.
for the property, saying is consideration provided under that original contract, the AB contract, which it certainly is, but it's consideration given indirectly by Mr. and Mrs. Brown when they made the share subscription. So they subscribed £160,000. The Upper Tribunal is saying £955,000 of that was the indirect giving of consideration to the vendor under the AB contract. Contrary to the findings of FDT, we find that no chargeable consideration arose under 45(3)(b)(2). And that underlying analysis that the share subscription is indirect consideration for the property under the top contract, the original contract, the AB contract, is fundamentally why the Upper Tribunal agreed with the first tier tribunal in respect to the position of Section 1745 not applied at all. Because I think both of the tribunal's analysis on that question is instructive as to the way they're approaching this legislation. Both considered that the share subscription price was consideration for the acquisition of the property under paragraph 1 of Schedule 4, if Section 45 didn't apply. Now, paragraph 1 of Schedule 4 is in the bundle at page 33 of the authorities bundle. And the point, of course, is the wording here is very similar to 43(b)(1 and 45(3)(b)(1). Paragraph 1, Schedule 4. The chargeable consideration for a transaction is, except as otherwise expressly provided, any consideration in money or money's worth given for the subject matter of the transaction directly or indirectly by the purchaser or person connected with him. So, what we see in both the Upper Tribunal and the First Tier Tribunal is that the court took the view that when looking at consideration for a transaction provided indirectly, you don't just look to the parties to the transaction. You can look beyond that, where there is a preordained scheme. That's evident at paragraph 53 of the decision.
Of the Upper Tribunal.
Of the Upper Tribunal decision. Forgive me, paragraph 52.
What page is that on?
On page 74.
Thank you very much.
After considering section 45, the Upper Tribunal notes there, indeed, were it not for the application of section 45 in this case, in common with the FTT, we would have considered that, notwithstanding the imposition of the company between the vendor of the property and Mr. and Mrs. Brown, it was Mr. and Mrs. Brown who provided the whole of the consideration for the acquisition of the property, and the SDLT would be chargeable by reference to that consideration. Given the preordained nature of the steps in the transaction, the share capital contribution by Mr. and Mrs. Brown was consideration given indirectly for the property, and therefore consideration for the purposes of paragraph 1 of Schedule 4. As we've said, that provision defines chargeable consideration money or money worth given for the subject matter directly or indirectly. So that analysis takes us to the Ramsey doctrine, the Hurstwood, and the principles of interpretation in the context of commercially irrelevant steps in a series of transactions. It's relevant to highlight that that's also what the Upper Tribunal was doing in its analysis of 45(3)(b)(1. Where there is a preordained series of transactions, it argues, under which a taxpayer injects money, they give that money indirectly for the purchase of the contract. And the legislation does not take account of the legalistic nature of interposing transactions or parties. You can look through to the commercial reality of what's going on, is broadly the submission.
You say that's wrong.
I do, yes. So, as I say in paragraph 14 of my skeleton, in applying Rosendale and Hurstwood in that way, the Upper Tribunal asked the right question. The question, of course, is what is the consideration paid indirectly? How much consideration is paid under the top contract is paid directly or indirectly by Mr. and Mrs. Brown?
Yep. The
legal question is whether the relevant statutory provisions construed purposely were intended to apply to the transaction viewed realistically. In this case, you might want to rephrase that as whether the relevant statutory provisions construed purposefully were intended to apply to the consideration viewed realistically, the consideration being what we're trying to identify under the statutory provision rather than the transaction.
It is on the consideration that the stamp duty determination bites.
Yes, and specifically whether the relevant statutory provisions construed purposely were intended to apply to the share subscription under this scheme, viewed realistically. That's that question applied to this particular arrangement. And I've said out there at 15 how the Upper Tribunal answered the question. I've already addressed you on that. And that takes us to, say, the line of cases ending in Hurstwood, beginning with Ramsey, of which there are more numerous than I can take you to today. But the point I
mean, the principle is now Rossendale. You don't need to go further back than that.
Indeed. And I've got perhaps if you think something necessary, I won't. I was planning to take you to McNiven about his mercantile. The principle, obviously, I want to get out of those is that there is no rule that where you have commercially irrelevant steps in a transaction, you ignore them for the purposes of tax law, whether or not there's a tax avoidance purpose. If the legislation, the purpose of the legislation, the meaning of the legislation, is to tax legal or juristic concepts or other kinds of specific transactions, you don't ignore those things because the commercial reality is artificial. And that's a proposition set out many times. As I said, I mean, I could take to paragraph 49 and 58 of McNiven, if you don't want me to.
Well, Rossendale says that.
Indeed, Rossendale
says that it doesn't help you to label steps as artificial, or I can't remember the other word that Lord Briggs and Lord Daggett used, but whatever it was, the fact that they're artificial doesn't necessarily mean you ignore them.
Indeed. And in the bundle at page 205, we have Mays.
Yeah.
And that's a good example of the application in a situation where you have some complex legislation that is very prescriptive and specific. The legislation is set out in paragraph 41. It's not set out, it's described at paragraph 41.
Of May.
Of Mays on page 216 of the authorities bundle. And and this is all about identifying and quantifying gains on life policies and for subjecting those gains to tax. Paragraph 43. The gains are to be taxed gains to be taxed are attributed by the legislation rather than the real ones. So it's a mechanism of allocating notional gains to be taxed. And what follows is a description of the terms involved. Words like premium and surrender. Section 540 defines the chargeable events related to policy of life insurance. Without taking to it, and certainly without trying to explain the entire code in that case, it's clear that in Mays we have a prescriptive statute code designed to do a specific job. It's targeted, it's precise. And the result is, of course, that you don't look at the economic substance, you look at the precise events and transactions as defined that the legislation taxes. That takes you to paragraph 77 of Mays. I went down on page 224. Thirdly, on the proper construction of the ICT provisions for the taxation of life policies, the statutory requirements as to the transactions to which the provisions were intended to apply were far removed from the kind of case in which the focus is simply on the end result, such as a loss. A reference to Rams itself, of course. In this case, the all-important corresponding deficiency relief was the product of real premiums paid in earlier stages for real life policies and real surrenders made in early stage. Although the corresponding deficiency was created solely to save tax, that alone does not entitle the court to disregard the fiscal consequences of payments of premium and the potential surrender from its creation. Fourthly, it would be an error which the judge did not fall into to disregard the payment of a premium at step 3 and the partial surrender at step 4 simply because they were self-cancelling steps inserted for tax advantage. It was right to look at the overall effect of the conduct of steps 3 and step 4 in the 7-step transaction in terms of the ICTA to determine whether it answered the legislative description of the transaction or fitted the requirements of the legislation for corresponding deficiency relief. So viewed, steps 3 and 4 answer the description of premium partial surrender. On the true construction of the ICT provisions which do not readily lend themselves to a purposive commercial construction, step 3 was in its legal nature a premium paid to secure benefits. And step 4 was in nature a withdrawal of funds. They were genuine legal events with real legal effects. The court cannot, as a matter of construction, deprive the events of their fiscal effects under the ICTA because they were self-cancelling events that were commercially unreal and were inserted for a tax avoidance purpose. And essentially, this is what I'm saying about Section 45 and the SDLT code. It's a complex and prescriptive code that is very precise as to what it does. Section 45 is perhaps an even better example of that. But in ignoring the approach of the FTT and the Upper Tribunal here was to take the concept of consideration giving indirectly under a transaction, under a contract, and to expand it to cover essentially the source of the funds. My submission is that consideration given under a contract for 45(3)(b)(1) must mean pursuant to the obligations of that contract. But I'd like to take a step back.
But does it have to be a contract? I mean,
it doesn't have to be a contract. It's notable that contract is defined for the purposes of Section 44 and 45 as any agreement.
yes.
So it's notable that the contract, as used in Sections 44 and by implication 45, which of course is a modification of Section 44, the word contract covers any agreement. So an agreement for no consideration, not under general law or contract.
So you're
nonetheless,
using the term in a...
we apply Section 44 on that basis. But you still need an agreement.
But what does indirectly capture?
The obvious interpretation in my submission is that it captures indirect payments. For example, if I pay via a bank or via some other mechanism, I am paying, for example, I enter into a mortgage agreement and the bank pays consideration, that would be an indirect payment. Fundamentally,
Well, the
also,
problem with that is that then the consideration will be indirectly given by the mortgagee, which doesn't sound right.
indirectly given by, sorry, I didn't hear who you said it would be.
I mean, just take a plain vanilla case. I agree to buy a house, put down the deposit. I now need to find the money to complete. So I go off to a lender. Lender transfers some money to my solicitor, holds it to the lender's order until such time as completion takes place. And then on completion, the money is transferred to the vendor, TR1 is executed, and I often register myself in the land registry. So who is giving indirect consideration in that case?
You are giving consideration indirectly.
Because I've raised the money
Yes,
through the lender.
it's being
And
provided
it's
on your
being
account.
routed through my conveyancing solicitor.
It's being provided on your account and at your cost. So you have an obligation under the contract to provide the consideration, and you've arranged for that to be provided. You've done it indirectly.
Well, why haven't I done it directly?
Well, my fundamental submission about the words directly or indirectly in brackets is that they are superfluous. They are belt and braces. They are clarification. If you said the chargeable consideration is the consideration given by the transferee, and there was an argument as to whether funds paid via a third party were consideration given by the transferee, I think it'd be clear what the outcome was. Absolutely take away those words in brackets, both in paragraph 1 of Schedule 4 and in 45.3b1, and the result surely must be the same. They're helpful in that they emphasise that whether the consideration is paid directly under the original contract or whether it's paid indirectly via a third party or some other payment mechanism.
It makes it plain it's not confined to direct consideration. It could be indirect.
But absent them, you might have an argument about whether indirect consideration counts. I think the outcome would be fairly plain. Because clearly, obviously, if I go into a shop and buy something with my credit card, my bank is paying. But I'm the one, you would not expect the outcome to be that, well, I'm not actually buying the goods myself. I'm not giving consideration. It's my bankers. Clearly, I'm the one with the obligation under the contract to purchase, and I'm arranging for it to be satisfied. So it seems to me those words, directly or indirectly, are to deal with the mechanism of payment under the contract. And the scope of what is consideration, directly or indirectly, is still confined by the scope of the contract.
The original contract.
The original contract. It might be helpful to take a step back here to the obvious purpose of section 45.3, and in fact 45 entirely. It's designed primarily to catch two vanilla situations, assignments and subsales. In an assignment, B enters into a contract with A, and before completion assigns their rights to C, perhaps for a small sum. C then gets to buy the property from A under the AB contract. C pays a bit of money to B for the privilege of doing so. A classic assignment. Under that arrangement, 45.3b1 charges the amount C pays to A under the assigned contract, because they take on the obligation to pay under that assigned contract, and they pay the money to A. It also taxes under 3b2 whatever they paid to B for the privilege of the assignment. So it captures the total they pay to both parties in return for the property. The second situation is a subsale, where B buys from A and sells on to C. Under that situation, C pays full consideration to B for the property they're buying from B. Whatever that is, B pays maybe a different amount of consideration to A, but that consideration paid by B to A is not caught under 3b1 because it's not paid by C. Now, you might say even in that, so again, that gives you a just outcome. What C pays for the property is taxed. But you don't double count what B pays to A and what C pays to B under a normal subsale situation. Of course, that's the situation we're in today. the fact that C's agreement to buy the property of B may or may not fund or provide the resources for B to purchase the property of A doesn't change that. If it was the case in the normal subsale situation, unconnected parties, A agrees to sell to B, before completion you have a subsale to C for full consideration. And it was the case that B didn't have the funds to pay A until C put it in funds for its subsale. Would it be the case that C was providing indirectly B's consideration to A? If it was, you'd have a double charge. That clearly can't be the purpose of this provision. And the reason that you don't get a double charge is because what C gives to B is consideration under the CB subsale. It's not indirect consideration under the AB top contract. It's not consideration under that contract at all. It doesn't provide anything under the contract. It doesn't have any obligations or rights under that contract. So how can it provide consideration under that contract? And the legislation uses the word under. It is simply an abuse of the meaning of the words to say that because in reality C's acquisition from B funds B's acquisition from A, C is taxable under little b1 when they're also clearly taxable under little b2. So that's why I say essentially that the scope of consideration under the original contract, which defines the scope of what we're looking at here, and whether or not that's provided by C is limited to what is provided by C under the terms of the original contract. I'd like to take a further step back, if I may, and go right back to the code and look at the way the SDLT Part 4 lays out its scheme. Because I know my learned friend submission will be that the purpose of SDLT, as set out in Part 4, is fundamentally an anti-avoidance purpose. And that's undoubtedly true. Prior to the introduction of Finance Act 2003, stamp duty was charged on documents with a physical stamp. This enabled all sorts of avoidance measures, essentially delaying completion, etc., to avoid having a stamp where people could acquire substantive rights over property without getting the purchase stamped. Part 4, Finance Act 2003, was a response to that. Okay, it was brought in to prevent avoidance. But that does not mean that the way it was applied was such that it looked to fundamental economic realities in composite transactions. It was not applied in a way that can look past the legalistic nature of what's happening. And in fact, quite the contrary. What Part 4 does is tax legal acquisitions of legal interests in land. When I say use the word legal interests in land, I'm going to, hopefully you can allow me to encompass equitable interests there. Obviously, land law interests in land might be a thing. So if we turn to Part 4, I'd like to illustrate this. Section 42.
Yes.
The tax is to be charged in accordance with this part on land transactions, whether or not there is any instrument affecting the transaction, etc. So we need to know what a land transaction is. 43. A land transaction, in this part, means any acquisition of a chargeable interest. So any acquisition of a chargeable interest. It's worth jumping to 48 there, straight away, on page 15. I'll come back to 43. Chargeable interest means an estate interest, right or power in or over land in the United Kingdom, or the benefit of any obligation, restriction, or condition affecting the value of any such estate, interest, right, or power, other than an exempt interest. The following exempt interests: a security interest, a license to use or occupy land, a tenancy at will, and a advance in franchise or manor.
None of that applies.
No, none of that applies here.
As I understand it, you accept that there was a land transaction
Oh, indeed.
here.
Yes.
The point is you didn't pay any money upon which stamp duty can bind.
But the point I'd like to make now is that this tax, the fundamentals here on what is a land, what is taxed, is the acquisitions of rights in land law. Right? It uses the language of land law. It doesn't create its own concept of what an acquisition of land is.
No.
It says an acquisition of a land as an estate, interest, right, or power. What are we to mean and understand by those terms? Well, the answer clearly takes us to the jurisprudence of land law and the body of land rights. That's what Parliament is intending. And that is the answer to the problem they were encountering, which was a stamp on documents is what we tax. They said, no, what we want to do is tax the fundamental acquisition of interests in land. Equitable interests, legal interests, it doesn't matter. If you gain a right over land, we'll tax it. A tendency at will is, they've decided there, is an exempt interest. It's not a sufficiently important or valuable right, so they don't tax that. But the language here is about legal rights over land. Legal, again, it's dangerous to use the word legal in the context of land law, but
I'm sure that what you say is sound, but what we don't need to be concerned with that, do we?
No. But the point is that this is not, the language used when referring to land transactions is specific and interested in legal status of what's going on rather than the commercial purpose. Okay, it's couched in terms of legalistic terminology. Similarly, going back to section 43, we see that acquiring an interest in land means becoming entitled to an interest or right. Again, it uses concepts of entitlement and similar to define what acquiring a chargeable interest, i.e. what a land transaction is. So we're going on to section 44 on page 8 of the authority. We can see the purpose, of course, here is that taking the broad notion of a land transaction, when you enter into a contract for purchase of property, you acquire an equitable right pursuant to established land law. So that's an acquisition of an interest in land. Section 44 is needed because Parliament decided that most property transactions are actually completed by conveyance, and it's the conveyance, or the taking possession, that is in fact commercially the relevant event. So what do? They don't broaden the concept of a land transaction or redefine it in their own terms to make account for that. They provide a specific set of instructions for how to deal with this type of land transaction. They say a person is not regarded as entering into a land transaction by reason of entering into a contract, but they are regarded as entering into it on completion or substantial performance, as defined. It's a very specific modification to the general principles. And section 45 takes that one step further, of course. And provides a specific set of instructions for how to relieve a subsale or assignment where the middle party never, in fact, gets the substantial benefit of the property. They never complete or take possession before they pass it on. And this is why, where you have multiple transactions involved in a single deal or arrangement, the legislation doesn't treat those as a single deal. it sticks closely to the idea of when you acquire an interest, as defined by our landlord in land, that's the taxable event.
Yes.
And where we have a series of such taxable events, we have special provisions to deal with them. We don't just join them all together and then recall the middle ones. So we're taxing each of them. So we provide special rules. And I've set them out, some of them at least, at paragraph 17 of my skeleton. The first is section 108. Which is paragraph 32, page 32 of the authorities bundle. It says transactions are linked to the purpose of, if they form part of a single scheme, arrangement, or series of transactions between the same vendor and purchaser, or in either case, persons connected. So note in this case that the AB purchase is connected to the BC. No, it's not. But it's a specific rule for what happens when you have commercially connected transactions.
Yeah. And you're accepting of it, says in paragraph 17, that section 45 is one of these strategies that the legislation has for catching or dealing with.
Indeed, yes.
A series of transactions.
Yeah. Another, obviously, is section 75A itself, which we'll come back to later. But of course, that takes effect when you have a series of transactions, not necessarily land transactions, and the SDLT payable on a combination is less than it would be if you just had this notional transaction as defined. So this is where you've got a series of transactions. Again, it doesn't.
So if I'm just make sure I'm following, the overall point you're making with this detail, it's not enough to just stand back and say, well, these are a series of linked transactions with the overt aim of avoiding the tax. They must be connected. The tax must be payable, because the statute goes to a micro level and says only these, you list 6, only these 6,
Indeed.
there are only 6
Yes.
apply, and you've got to come within one of them.
Yes, the question, Rosendale and
Yeah.
Hurstwood, is what did Parliament intend
Yeah.
to refer to?
It didn't intend to
when
catch
it referred to
absolutely-
transactions.
It didn't intend to catch absolutely everything that might
45B. Yeah,
look like this.
indeed.
Yeah.
It intended to refer to transactions, in their legalistic context. Again, McNiven obviously makes a distinction between commercial and juristic concepts in legislation.
That's rather gone out of the window, hasn't it?
Well, Barclays Mercantile goes back from that at some point and says that is again too simplistic. Again, you've got to really look at the legislation, what it means to refer to. But it's a useful guide in this case, given that the legislation is so clearly referring to legalistic concepts under land law. Back to paragraph 17 in my skeleton, the list of other provisions I've mentioned there. Your lordships have already noted that, of course, I'm saying section 44 and 45 are again specific provisions with how to deal with series of transactions, so as to get the purposive substantive effect Parliament wanted. I also note a couple of the other rules there. Section 71A, which is alternative property finance rules. They are on page 21 of the bundle. And 71A there sets out 4 conditions, A to D, that activate that section.
Sorry, where are you now?
So page 21, the bottom of page 21 of the authorities bundle, section 71A.
Section 71A, which starts at the very bottom.
Indeed. Yeah. These were provisions obviously considered in Project Blue at some length. and you can see there, this section applies where the arrangements are entered into between the person and the financial institution under which, and then there's 4 conditions. Condition A defines the first transaction, and then C, a second transaction. And that activates this provision, which then has itself a series of specific rules for how to apply. So again, where you have a specific series of transactions that produce a specific rule. Of course, the idea behind Section 71A is simply that Islamic financing is not penalised as compared to general mortgage arrangements. Mortgages are security interests and therefore not chargeable under Section 43. And therefore banks are able to lend money to purchasers without incurring charge for SDLT. Straightforward. That, obviously, the whole point of Islamic financing is to get around the concept of lending, and they're not security interests. They actually buy the property and lease it back, the banks. And that, obviously, would penalise them under the normal application of the provision of SDLT, because they're acquiring the land and then there's a lease. So this provision, 71A, deals with that by essentially setting out a code that gives you the same position, and you end up in the same place as if it was a bank.
Our focus has to be Section 45,
Indeed.
doesn't it?
Yeah, but my point is, again, the question is, how did Parliament intend Section 45 to be applied? That needs to be seen in context, and that's why I'm taking you to these other provisions.
It needs to be looked at as being of a type with the other 5 also similar bespoke provisions.
And when we see the way the courts have approached in Project Blue, Section 71A, in DV3, the application of Schedule 15 and the partnership transaction rules, what we see, quite rightly, is a detailed analysis of what the provisions do.
It might be said that in Project Blue, where the Court of Appeal went wrong, whom I was one, was to say this is a real acquisition by the Islamic financier, and it's not surprising, therefore, that there's a different tax regime for somebody who really does acquire the interest and then leases it out to the borrower, than if it was a straightforward traditional mortgage. But the Supreme Court said no.
You need to follow through the legislation by the letter, and in fact what you come out with is no charge for tax, and that's a lacuna in the legislation.
I think we took the view that HMRC has simply tried to tax the wrong person.
Yes, indeed. Yeah, well, it did.
And the Supreme Court said no, they taxed the right person.
Yes, but they tax the right person under Section 75A.
Yeah.
Which of course is the backstop for if these very specific provisions produce an outcome that doesn't seem right economically. And that's what it's there for. It's to say, well, we have very specific rules about how to approach series of transactions. If, at the end of the day, you're left thinking, but P has acquired a property from V fundamentally, and they're not paying any tax because of the application of all these provisions, well, we have a rule, 35A, that imposes a charge. Yeah. And again, all of this leads to the correct approach to 45.3, which is to read it according to what it actually says, and not to step back and go, well, yes, what C is actually providing consideration under the AB contract.
Yeah.
Yes.
You construed realistically is providing consideration of the AB contract. 45.3 is aimed at what C, Mr. and Mrs. Brown, pay under the contract between A and B. And in this case, they didn't pay anything under that contract. The company paid the sum.
Yes.
Right.
Forgive me, I'm slightly lost in my skeleton.
Well, you were on paragraph 17 with the list.
Yes, indeed. I'm grateful. Yeah, I set out a number of the exchanges rules I mentioned there.
Yeah.
They, again, are a set of provisions that say, well, where you've got 2 exchanges of properties, we calculate the consideration of that in a specific way.
Yeah.
There's similar rules in regard to construction works in paragraph 10 of Schedule 4. In Schedule 4 in itself is generally a prescriptive way to calculate consideration in certain situations. And I'll note, of course, that all those provisions listed, Schedule 4, all those in Schedule 4 start with the condition that something's consideration. And so they all say where a property is provided in exchange for another property as consideration, you calculate that consideration a certain way. Similarly, construction works. Where construction works are consideration for an acquisition, this is how we determine the amount of charge of consideration. Similarly, the other provisions I've listed all start with the position that there's a land transaction. That they are, and that's the relevance of them.
But your point is that the whole system is prescriptive. Certain conditions have to be fulfilled, and the number of your submission is basically in paragraph 20 of your skeleton.
Yes.
Yes, indeed, exactly. Indeed. And so with that bit as well as I can, it's worth turning to the consequences of if I'm wrong. Because if essentially the job under 45(3)(b)(1 is to look back and say, well, where did the money come from? Were there arrangements in place to provide this money for the AB contract? Then there are real questions about how far you take that and what does it catch. For example, in this situation, we had a property was identified by Mr. and Mrs. Brown, and then the company was interposed and the money paid, and after the decision to buy was essentially made. Would you get the same outcome if I thought I need to buy a house, so I'm going to establish a company and put £1 million into it, that's my budget. I'm now going to go out and look for a house. If I can find one that's suitable that I like, I'll use the company to buy it and distribute it down to myself. Is that sufficiently preordained, such that my share subscription is consideration for the AB contract? I make that share subscription at a time when I don't even know who A is, who the vendor is.
But you make it because you want to buy a house
I make it
for £1 million.
yes.
So it's not just money in a company. It's there for that express purpose.
So is this does one need a purposive test? For example, because to take a step further back, what if the situation was I have a property company that I funded many years ago and that trades as a property business. I decide I need a house for myself, so instead of buying it myself, I get my company, which is in funds, to buy the property and sub-sell down to me or distribute out to me. Again, there's that share subscription, the amount that is in this case said to be chargeable consideration under the AB contract. Can that really be said that years ago, 10 years ago, when I set up my business, I was providing consideration for the AB contract? I would say certainly not. Does that mean we need some sort of purposive test in order to distinguish what consideration under the AB contract means? If the answer is yes, that the purpose of the share subscription is what matters, that sits very poorly, I would suggest, with the scheme of SDLT. Even Section 75A doesn't include a purpose test. The legislation goes to great lengths to avoid any sense of purpose. I note, of course, that Schedule 2A, which replaced Section 45 some time ago, does have an anti-avoidance purpose test. But the legislation that's enacted at the time did not. So where does this interpretation of consideration under the AB contract?
Different cases will have to be looked at on the facts of those cases.
Exactly.
We're not in that territory.
No.
We're in the territory where it's much more clear-cut.
Indeed. But my point is that we're making the law unclear if we go down this route. There'll be situations where parties will have to be asking themselves, hang on, this money ultimately came from me. Does that mean I provided it?
Well, there may be cases where because of the time gap, for example, or because steps are not preordained, it doesn't qualify as consideration provided directly or indirectly. But nevertheless, as I think you concede, it still doesn't work because of the connected persons point.
Indeed. And the point is the connected person point renders all those questions unnecessary. We don't need to be having a question about, well, what is the purpose of this share subscription when it was made, and whether it classifies as part of a preordained scheme. Parliament has dealt with this question by the connected person slip. It's very clear. If I set up a business, and 10 years ago I put in money, and it's a property business, and then now I decide I want a house and I buy it, distribute it to me, I pay tax under 45(3)(b)(1) because I'm connected to the company. And it acquired the property and subsells out to me. So we don't have this problem if we take a straightforward approach.
But the fact that the connected persons provision is there doesn't avoid the need to answer whether there is indirect consideration, does it?
No, indeed. Yes, I mean, that's the issue today, is whether there's indirect consideration. That's what the Upper Tribunal decided there was. And what I'm saying is wrong.
Yeah.
But my submission is that in finding that the share subscription was indirect consideration, the Upper Tribunal was opening up uncertainty where none was intended. It was opening up a purposive, sort of a commercial construction of Section 45 where none was intended. The legislation is designed to tax the transactions, the acquisitions of interests in land. And the contract for the acquisition of interests in land, the AB contract, the question is the consideration provided by C, by Mr. Brown, or person connected with them, consideration under that contract? And the share subscription was not consideration under that contract. The share subscription was consideration for shares.
Yes.
And it's perhaps query whether it's necessary to touch on, obviously, the scope of the word consideration in SDLT generally there. It's not defined. Chargeable consideration is defined, obviously, in Power 1 of Schedule 4. The consideration is a word clearly taken directly from contract law. There's no other possible meaning. And there's no reason in this context to impose on it some broader concept. Now, that doesn't get me home, and it's not exactly what the Upper Tribunal was doing. It is what the first-tier tribunal did when it decided under little b2, the share subscription was consideration for the transfer of rights. Well, perhaps. Essentially, it decided that the share subscription was indirect consideration for the transfer of rights. No, little b2 doesn't use the words direct or indirect. It just says we have to tax consideration given for the transfer of rights. Query whether that catches indirect consideration for the transfer of rights. In my previous submission, I would say it does. But consideration refers to consideration under the contract in little b1, and that's what it says, consideration given under the contract. And we can't expand that beyond the contract. As I say, I don't think that's my learned friend submission today. The submission is the consideration provided by B, the company, under the contract, was also provided indirectly by C. As I say, which gets us back to my main submission. There is no scope here for what is the source of the funds when thinking about provided indirectly. It's not asking what is the source of the funds.
Yes.
And I note paragraph 21, 2 of my skeleton. An alternative analysis for a scheme like this.
The distribution which you refer to in paragraph 21, if I've understood correctly, was accompanied by a TR1 executed by the company in favour of Mr. and Mrs. Brown, showing no consideration.
That's right.
And it was that TR1, I take it, which was registered at the Land Registry.
Yes. So it's a classic subsale in that sense. The company acquired the property and a
But
meeting.
it wasn't a transfer direct from Mr. Ham.
No.
There was a transfer from Mr. Ham to TR1 from Mr. Ham to Earlsfield. Earlsfield, if I've understood correctly, never got itself registered as proprietor. It simply executed another TR1 to Mr. and Mrs. Brown, and they then were registered as proprietors
That's right.
of the house.
Yes, that's right, as I understand it. And the clear point is obviously that was a subsale with a minute point of ownership for the company in the middle, rather than a direct transfer from A to C,
Yeah.
which would be the situation in an assignment if they assigned it. And of course, if they had assigned it, if they'd assigned the contract and then paid themselves, that would have been a payment by a person connected with C under the AB contract.
Yeah.
In any case, and there may have been you wouldn't need the distribution. But in that case, it would be very clear how 45.3b applies.
Yes.
I'm just seeing if where we've got to with this, if there's anything else I need to deal with. Paragraph 26 of my skeleton
Yeah.
Makes
so
an-
you've already covered this.
I think so, yes. The provision asks who gives the consideration under the AB contract.
Yeah.
And it's clear in this situation that it was the company, not C, indirectly or otherwise. Giving consideration indirectly still means you have to give something under that contract. And they bought the shares. They didn't give anything to A, the vendor. Which is another sense in which the language of this provision indicates an offense interpretation is wrong, and that you need to take a more technical and restrictive approach to what indirect consideration means. I wonder how much weight can be put on the tense used in section 45.3b, where it says the consideration to be given by C or a person connected with them. Obviously, you know, you could argue perhaps that means that, well, it has to be in the future, and given the share subscription happened beforehand, that's not consideration to be given by C, it's already been given, and that the timing is important. I would suggest probably, indeed, it's to be given under the contract, to be given pursuant to the terms of the contract, that is the real intent of that phrasing. That there's an obligation in order to complete, that consideration must be given, and it's given by C in pursuant to that obligation.
Yeah.
Right.
Reminded of that phrase that language is hard to describe in words. But we will try. So I think I don't have anywhere else to go on 45.3b.
No, well, I think you've been very helpful and very clear in your submissions.
I'm grateful. And which does give me some time, I'm pleased to say, to move on to ground 2.
Yes, which is a luxury you didn't
And the
have.
spirit of determination. This is paragraph 28 in my skeleton. The decision also decided in the alternative that the FGT was wrong to find that determination did not cover the existing notional transaction on 75A. So what happened in the first instance is the first tier tribunal accepted my argument that a determination under paragraph 25 must be in respect of a specific land transaction, and that the section 75A transaction is different to the notional transaction under section 45. The notional transaction under section 45 is what was assessed by the determination, and not the 75A transaction. And starting with the Upper Tribunal, page 80 of the bundle, paragraph 83.
Sorry, Upper Tribunal.
The Upper Tribunal, page 80, paragraphs 83 to 85,
Yeah.
is the reasons for the Upper Tribunal's decision. Paragraph 85 perhaps is the most instructive. Paragraph 25 of Schedule 10 enables HMRC to make a determination of the SDLT in the case of a chargeable transaction. In this case, the chargeable transaction was the acquisition by Mr. and Mrs. Brown of the property. And then at the end of paragraph 85, whether or not the liability of SDLT arises by reference to an action transaction or a notional transaction, there is still only one transaction, namely the chargeable transaction, which is the acquisition of the property. So I say that's an error of law. I say it doesn't accord at all with the scheme of SDLT, the concept of chargeable transactions. And to demonstrate that, let's start with 75A on page 24. This section applies where we have a disposal of a chargeable interest and another person P acquires it or chargeable interest derived from it. We have a number of transactions, and we're going to assume and also see the stamp duty payable is less than it would have been on the notional land transaction. And so we're assuming, obviously, for purpose of this ground, that this section applies. The key paragraph for our purposes is subparagraph 4, where this section applies. Any of the scheme transactions which is a land transaction should be disregarded for the purposes of this part. But there should be a notional land transaction for the purposes of this part, effecting the acquisition of V's chargeable interest by P on its disposal by V.
So what we assume on the facts of this case is that Mr. and Mrs. Brown acquire the property on its disposal by Mr. Ham. That's our assumed fact.
Yes, and Mr. Ham disposes of it, and Mr. and Mrs. Brown acquire it.
Yes.
Yes.
So then we've got to see what return has to be given. And we're told that by section 70, whatever it is, I've forgotten now. 5, is it? No. Section 76. So the purchaser, that is Mr. and Mrs. Brown, have to deliver a land transaction return in the case of every notifiable transaction. 77 tells us what a notifiable transaction is, and we're told that any other acquisition of a major interest is notifiable. So here on our assumed facts, it's Mr. and Mrs. Brown who acquire the freehold. So they have to submit a land return.
If it's notifiable. Of course,
Yeah.
a acquisition that for no chargeable consideration is not notifiable.
But the notional transaction is for consideration.
Yes, indeed. Yeah. So yes, going back to 75A,
Yeah.
there's obviously an imposed consideration on the notional transaction that's set out in that section.
Right. So Mr. and Mrs. Brown under this notional transaction have to submit a land transaction return.
Yes. Yes. If they have a liability on this, they must submit a return.
And that land transaction return should declare the amount of the consideration as effectively what Mr. Ham got for his property.
Yes. But the effect of section 75A(4) is to disregard all the other land transactions and to say we take no account of them for SDLT purposes.
Yeah, but you still end up with the acquisition, the actual acquisition in the real world.
There's a real acquisition in the real world of an interest in land. It's a land transaction, so it's the acquisition of a chargeable interest.
Yeah.
So it's an acquisition of a chargeable interest in the SDLT world, to take the DV3 sort of approach. And that notional transaction it has, as I say, a defined consideration under 75A5. It also has a defined effective date under 6, 75A6.
So under 5, it's the chargeable consideration under 4B is the largest amount given by or on behalf of any one person by way of consideration for the scheme transactions.
Indeed. Yeah. Received by or on behalf of V, yes, exactly. Or given by any person. So in this case, that gets you to the 960,000 given by Mr. and Mrs. Brown for the share subscription.
Being the largest figure.
The share subscription is a scheme transaction.
And that's why the first tier tribunal fixed on that figure.
Indeed.
Yeah.
So with that under our belt, we can turn to the determination provisions in Schedule 10. Which are at page 55 of the authorities. One.
25.
Paragraph 25 on page 50.
On page 55. Yep.
Paragraph 25.1. In the case of a chargeable transaction, no land transaction return is delivered if, in the case, the Inland Revenue may make a determination to the best of their information and belief on the amount of tax chargeable in respect of the transaction. So, a chargeable transaction is a land transaction that's not exempt from charge. That's section 49. So what we need, what we're looking for a determination is if we have a land transaction that's not exempt, for which no return is delivered. So the determination must be made in respect of a specific chargeable land transaction, an acquisition of a chargeable interest in land. It's defined specifically by reference to the SDLT concepts of chargeable interest, acquisition of chargeable interest, and transaction. That's what the determination is in respect of. And so just as in DV3, if for the purpose of SDLT you don't acquire a chargeable interest, then there's no land transaction, no determination is issued. Even though there is an acquisition of a property interest outside the terms of the SDLT provisions. So that's the basis of my submission, that the determination must be in respect of a specific land transaction. Now, of course, it would be possible for HMRC to issue two determinations in the alternative. There wouldn't be any problem with that. It could do so in the same letter. And alternative grounds for charging a specific land transaction are clearly permissible too. There's no restriction on those kinds of things, but it's clearly necessary to issue a determination for each land transaction they wish to assess.
We're dealing with a case where no land transaction return is delivered by the filing date. So HMRC are not notified by the acquirer of the acquisition. How do HMRC find out that there has been an acquisition, except perhaps by consulting the land registry?
That, I believe, is the general way.
That's what they do.
Yes.
So all they would know is that there was a new registered proprietor of the interest. They would have no idea at all from the land registry how it came about that registration took place.
No.
How would they know this is a Section 75A case as opposed to some other sort of case?
Well,
all they know is that there's been an acquisition and nobody's told us about it.
Yes, that's true. But they have significant information powers in order to find out what happened that they can deploy before issuing a determination. And or if there's any uncertainty there, they can issue determinations in the alternative. There's no problem there. And it's worth remembering the role the determination plays in the assessment machinery. When a land transaction return is given, HMRC can issue a determination. That takes the place, under paragraph 26, as a self-assessment by the taxpayer. That self-assessment, deemed self-assessment, can be replaced by a real land transaction return by the taxpayer. They then have an opportunity in paragraph 27 to submit a return of their own, which displaces the determination. So the whole point is that, well, if you haven't submitted a return, we can just decide how much tax you owe. And if you're not prepared to then make a decision for yourself, you'll have to accept our decision. So it's a rough and ready measure to begin the process.
Yes. A wake-up call.
Indeed.
Certainly would be. Just help me, I think I may have missed a step, but you accept that Section 75A applies to this case, that the revenue would have been entitled to rely on Section 75A and entitled to make a determination. And I thought the point of this part of the case was about the scope of the determination, not whether they could.
Yes, obviously this is made on the basis that 75A applies.
Yes, but at the beginning of the case, you said the scheme doesn't work. Second reason, because of Section 75A.
Yes, indeed. But the scheme doesn't work because there is perhaps a point to be made here that if the connected party limit applies, then Section 75A doesn't.
No, all of these things are mutually exclusive. Well, a lot of them are.
But on the basis that there is no charge under Section 45, for the reasons we've discussed.
Yes, so we're in the
connected
territory
party
of
arguments
Section
put
75.
aside.
Yes. But I had thought it wasn't, if we're in the Section 75A territory, it's not a question of whether it applies or not, it's a question of what the figure is for the scope of the determination.
It's a question of what is the scope of the determination, whether this determination captures the 75A land transaction.
Yes, so this paragraph 25 that we're on at the moment isn't really directly in point here, because they were entitled, if we're in Section 75A, they were entitled to make a determination.
There's no doubt they were entitled to make a determination for the simple reason that no land transaction was returned submitted.
Yeah.
And they managed to make a determination in respect of the notional transaction under Section 45, which is what they did.
Yeah.
They didn't make a determination under Section 75A, or rather, they didn't make a determination in respect of the 75A transaction.
Well, they didn't say what it was. If you go to page 126 in the court bundle, this is the covering letter. And the second paragraph says, I've examined HMRC Land Registry and Companies House records, concluded the acquisition of this land property was a chargeable transaction, and a return ought to have been made. I enclose a determination for the correct amount of stamp duty land tax. You go to the determination on page 128. It just says revenue determination, acquisition.
Indeed.
So that's all we know. There's been an acquisition. We don't know by what steps that acquisition took place. The revenue are saying there's been an acquisition, and we are assessing SDLT on it.
Indeed. But as in the question of what land transaction did the determination relate to, that's a question of construing the documents, as you rightly say. And we have in the bundle a case on that point in relation to closure notices. It's the BK and Lavery property trading case, page 271 of the authorities.
Of the authorities?
Yes.
Tab 18.
And this is a case that concerns, amongst other things, a closure notice. And at paragraph 36 onwards, the Upper Tribunal considers how one should approach the meaning of a closure notice. And in particular, is it a question of fact or law? We do not agree with the appellant. The identification of a conclusion and closure notice is solely a question of law. Whilst construction of a document is a question of law, the identification of any relevant surrounding circumstances requires questions of fact to be determined. Quoting quickly. As already discussed, the closure notice must be read in the context of the inquiry that preceded it in order to properly understand its meaning. Identifying the context is clearly a question of fact. And then there's a quote from Town Cashback at 38. I would leave it to the commissioners and now the first tribunal to identify the subject matter of the inquiry and the subject matter of the conclusions. In doing so, the first tribunal will have to balance the need to preserve the statutory protection of the taxpayer afforded by notification that the inspectors completed the inquiries and the need to ensure that the public are not wrongly deprived of contributions to the fisc. It is to be the special commissioner and now the first tribunal that the statute looks to identify what section 28ZA describes as the subject matter of the inquiry. The misfortune to differ from Justice Henson for the reasons I've given earlier, it was a matter for the special commissioners to identify the subject matter of the appeal. So for those reasons, my submission is, firstly, it's a question of fact as to what the scope of what the determination says and what it means and how to construct it. Secondly, one needs to look at context for that. Thirdly, the context makes it evident, entirely clear that this was a determination in regards to Section 45, under the Section 45 notional transaction, or a determination on the notional transaction, and not in regards to 75A. And in fact,
why are you able to make that submission when, as Mr. Lord says, the correspondence doesn't pin the colours to Section 45, and why should the revenue be required to be so specific at this stage, given that it's the opening of the process with the discussion with the potential stamp duty payer? Why can't the revenue be in a position to say, well, this is our determination? The legislation provides a number of routes to that. There are alternative routes, but the end result is the same. This is the figure, and this is what we're asking for. Yeah. Why are they precluded at this stage from relying on Section 75A?
Because the legislation is very specific about a determination must identify a land transaction. And a Section 75A land transaction is not the same land transaction as the Section 45 land transaction. The legislation specifies that they are different land transactions. And they have potentially different qualities, different dates, effective dates, and different consideration, different parties even. It's quite possible that the parties under the notional transactions are different to the ones under Section 45. So there are good reasons that, unlike in a closure notice situation, where the language is much broader, and I'll come back to that in a second, a determination is a much narrower tool. It must be used more specifically. As to how I can make the submission about the scope of this determination, I've referred you to a passage which says it's a matter for the first tier tribunal, and of course, in this case, the first tier tribunal did decide that this determination was not in respect of the 75A transaction. That's paragraph 116 on page 121 of the call bundle. Therefore, it falls to be decided whether the decision made by HMRC and then notified to the appellant was in respect to the actual acquisition of property by C from B or the notional transaction under 75A.
But that's a consequence of what he decides is a matter of law in paragraph 112.
Yes.
If he's wrong about that.
If he's wrong about the law, it doesn't matter. But my point is, when we don't need to go to the law if it was decided that this determination was in respect of, in the alternative, for example, that it referred to the Section 75A transaction. if it could be read as a determination in the alternative in regards to the section 45 notional transaction or the 75A notional transaction, then that would be fine. But as a matter of fact, as set out there by the FTT, paragraphs 117 to 124, this was a determination in respect of the section 45 liability, the land section 45 land transaction.
Yes.
So that's a decision as to the construction of this determination and its scope. So then we come to the legal question as to whether or not, in fact, a determination must be limited in this way. Now, I've already set out the legislation and explained why the terms of the legislation are restrictive, because they're couched very specifically in terms of a land transaction, an acquisition of a chargeable interest. And the legislation is very specific. The 75A land transaction is different to section 45A. So if it just refers to one, it doesn't refer to the other. My learned friend relies on Project Blue, which discussed a similar issue at this report in relation to closure notices. And this is worth considering, page 362 of the bundle.
22.
362.
362. Yeah.
So here at H1, PBL submits that H1 saying anyway not entitled to pursue their claim for the SDLT because they had no power to amend the SDL return lodged on its behalf relating to completion of the contract, because it was not a return relating to the notional transaction on 75A. So this is essentially the same argument put there. And at 84, that challenge is rejected.
Right.
The key passage at 83, I do not accept that submission. The answer lies in the terms of Para 13 of Schedule 10, which sets out the scope of the inquiry which HMRC may make under Para 12, and HMRC's powers on completion. Paragraph 13 provides, so far as relevant, an inquiry extends to anything contained in the return, or required to be contained in the return, that relates to the question of whether tax is chargeable in respect of the transaction or to the amount of tax so chargeable. So it relates, Para 13, anything contained in the return that relates to the question of whether tax is chargeable in respect of the transaction. Very broad language. Contrast that to paragraph 25, and there are obviously obvious differences. So you can't transpose the reasoning in Project Blue across closure notices across into determinations. And it's worth in that context also to go into paragraph 36, Schedule 10. Which is another reason why these determinations need to be treated differently.
Paragraph,
So, paragraph
36 of
36.
Schedule 10.
36, yes.
Page?
On page 60, that's 62, but the relevant passage I want to take you to is subparagraph 5A. Maybe it's best to start at page 62,
Yeah.
paragraph 35. An appeal may be brought against little e, 35(1)e, a revenue determination under paragraph 25.
Yeah.
Paragraph 36 then contains some terminology about notice of appeal, and paragraph 5A, subparagraph 5A, 36, on the following page, says the only grounds on which an appeal lies under paragraph 35E are that, and then it lists them. The purchase to which the determination relates did not take place. Now, purchase, note the use of that language, not the land transaction, but the purchase. The interest in land to which the determination relates has not been purchased. Again, not the land transaction didn't happen, not that there was no land transaction. And again, use of the word purchase. The contract for the purchase of the interest to which the determination relates has not been substantially performed.
Is purchase a defined term in the Act?
No.
Normally it speaks of acquisitions rather than
Indeed,
purchases.
yes. And it speaks of purchaser sometimes. But purchase here is clearly, again, Hurstwood, this is a clear indication that this is a provision not intending to restrict itself to SDLT concepts. Contrast that to paragraph 35. And of course, that means that the only way this appeal can be brought is that the land transaction is not one for which the self-certificate is due. For example, in this case, because the land transaction is exempt from charge under Schedule 3, in this case, because it was not for consideration. That's the essential basis of this appeal, is that the land transaction was the subsale, the distribution from the company, which was not for consideration and therefore exempt under Schedule 3.
And what is a self-certificate?
I can't, off the top of my, I'm afraid I can't tell you.
Normally,
you would have
put in
a land transaction return.
Yes,
indeed. I'm struck by that now as well. May I come back to that perhaps after lunch?
Yeah.
Just to go back, you took us to the section in Project Blue, paragraph 81 onwards, about procedural challenge, and you said that the HMRC rely on that. I'm looking at Mr. Elliott's skeleton. He does rely on Project Blue, but not in this context. He relies upon it at paragraph 31, subparagraph 2, which seems to me a wholly different point, which was that, to meet your point, that the Upper Tribunal approach means there's no need to resort to Section 75A. Have I misunderstood?
My Lord, I will be relying on Project Blue the same way I did before the Upper Tribunal.
Right.
The Upper Tribunal accepted my submission that Project Blue Supreme Court on this issue does provide some support for the submission.
Right, very
on
up.
procedural issue. If I can
Good.
assist my learned friend, he's not tilting at a windmill.
No, good, there we are.
Okay.
Thank you. That's helpful.
My Lord, also, in terms of self-certificate, a quick search has come up with paragraph 79 of Schedule 10. Sorry, Section 79
Section
of the part itself.
You've probably got that somewhere, haven't you?
It is. It's on page 29 of the bundle.
Tab 5. No. Tab 4.
79. Registration of land transactions.
Indeed. And you'll see there down at paragraph 3 on the next page. Subsection 1 refers to a certificate.
So B is a certificate by the purchaser, but I'm not sending a return.
So this is a certificate as to compliance with the requirements of this part. So this is a requirement to issue a certificate to the land registry that stamp duty has been paid or the law has been complied with. And subsection 3 there says certificate of the purchaser, no land transaction is returned is required in respect to the transaction. That's the self-certificate. Subparagraph 5, Schedule 11 makes further provision about self-certificates. We don't have that before us. But
So does that conclude your submissions on ground 2?
It does. And so, much far ahead of schedule. I think I've come to the end. Unless you have any further questions.
No?
May I just check with?
Yes?
Do we want to rise for it? Do we want to just clarify our thoughts before we get
Mr. Birkbeck, it occurs to the three of us that it's sensible for us to take a short break now just to clarify our thoughts. That will give you a less pressured opportunity to take instructions. So please, if anyone wants to leave for personal circumstances, do, but otherwise stay put and we'll be back in about 5 minutes.
I'm good.
Why is it on?
Ramsey. because Ramsey says no, you tax B. Sorry. I'll just make completeness. That's a possibility. I mean, you can just point to this. It's just not good for us. That's what that case, the other case says. That's what the first tier tribunal said in that other. No, not if. You just look at C's distribution. What when you look at that section 45 provides a notional transaction. Section 45 there's no notional transaction. So A and C. He's given no consideration. He's not capital. So 75 A there's no scheme. There's no scheme that works. B. Should have been taxed.
Come on, Becky. All rise.
Is there anything further, Mr.
No, I have nothing more to add.
Thank you. Thank you very much. Yes, Mr. Elliott.
Subject to any indications from the court, I shall address the grounds in order. Firstly, the application of section 45 and then the procedural issue on the determination.
Yes.
In relation to section 45, I propose to proceed as follows. Firstly, I would like to emphasise certain factual findings, very briefly. Secondly, I'd like to consider section 45 itself, and just to go through it, say at quite a high speed, but to emphasise certain points. Thirdly, apply section 45, all three analyses on which HMRC rely in the alternative to identify the chargeable consideration in this case. And then finally, I will come back to address the procedural issue in relation to the connected persons argument. Which is
Yes.
Before I launch into that structure, there are three preliminary observations which I'd like to make about the SDLT legislation. Firstly, just to make sure the court is aware, section 45 no longer exists. Following a number of attempts to take advantage of section 45 with marketed avoidance schemes, such as this case, in 2013 section 45 was essentially replaced with a more comprehensive regime in Schedule 2A, which is in your bundle, but it's not relevant, so I'm not going to take you to it.
Have we got Schedule 2A?
You do, yes, you do. It's in tab 8.
Tab 8.
Court is interested.
Yeah.
It's a whole schedule to replace what one provision previously did. Of course, though, point almost doesn't need to be made. The fact that Section 45 was repealed is not some form of admission that these tax avoidance schemes ever worked. No pre-planned tax avoidance scheme of this nature or variations have ever been found to work by the courts. The second point is about the interaction between Section 45 and 75A. And once again, to make sure this point is clear, Section 45 existed in the form that it applies before this court at the date that the SDLT code was created, before the introduction of Section 75A, which was only introduced as a specific anti-avoidance provision later. So had they been introduced together, there might be some force in saying, well, you have to read them together, and that maybe if there are any defects in Section 45, they can be remedied by Section 75A. But that can't be correct, because Section 75A wasn't introduced until 2007. So HMRC submit that Section 45 itself, on its own, must be capable of providing an outcome which accords with the intention of Parliament, without resort to provision introduced later. And in terms of that intention, of course, we need to look at the purpose of the individual provision, but it's also permissible to look at the wider purpose of the entire code. My learned friend has beaten it to me and accepted it, but the purpose of the entire code was to prevent avoidance. Just very briefly, it's in the authorities bundle, tab 32, right at the end, page 621, is the explanatory notes to FA 2003, which introduced the SDLT code. 621 is the start. Clause 42 becomes section 42, which is the provision which says, is SDLT, it's going to be a new tax. And if I could ask the court just to consider clause 9 of the notes on page 622. And of course, this was the legislation, as I said, as introduced, which did not include Section 75A. So interpreting the legislation, whilst we have to look at the specific provision, HMRC submitted is also relevant to consider the wider purpose of the legislation, which, as stated in the explanatory notes, that purpose includes preventing avoidance and ensuring purchasers pay their fair share. Turning now to the four parts of my submissions on Section 45. First part, some brief observations on the facts of the present case. This is a marketed SDLT avoidance scheme through which the purchaser, in the case, of course, the purchaser in this case is actually two purchasers, Mr. and Mrs. Brown acting jointly, want to acquire the freehold interest in a property, and through a number of transactions involving a company, which were undertaken only for the purpose of avoiding the tax, they did purchase that property. They did acquire it. And the First Tier Tribunal found, as a fact, at paragraph 6 of its decision, not only that the steps in that arrangement were part of a plan, but that there was no practical likelihood that the remaining steps would not be taken unless there'd been some problem with the actual conveyancing. And just to emphasise that point, a document to which both the First Tier and the Upper Tribunal were taken is the planning document, which is in the supplemental bundle at tab 14, page 157.
Thank you.
Because I emphasise that's an important finding of the First Tier, which is not challenged, and it's not a finding that it makes off the cuff.
So if you want us to read the
It's,
whole
it's
of
page
this?
157. Could I just ask the court to read page 157 and just the top paragraph of 158?
Yeah. Yeah.
Ultimately, court needs to apply the legislation to the facts of this particular case. I appreciate my learned friend would like to expand and say there might be uncertainty in other cases. Well, they don't concern us. Nor will they. Because this provision is dead. It doesn't exist anymore. The only thing left for the courts under Section 45 are these types of schemes. Of which I believe, since the court asked earlier, there are two sitting behind.
There are what?
There are only two, I understand, sitting behind this case at the moment. There are some. Appreciate they may not be organised. I'm not suggesting my learned friend is sort of lead case or anything like that, but HMRC are aware of two others which are waiting. The rest are all settled.
I haven't studied Schedule 2A. Does it also use this phrase directly or consideration directly or indirectly?
My lords, we'll double check that. There
You
is
say,
another
you say this point is no longer matters. Well, if it's used somewhere else, it might. I mean, it's used in the definition of chargeable consideration, isn't it?
It is used in the definition of chargeable consideration, yes, which is the provision I will be taking. It shows the breadth of what is meant by chargeable consideration under the SDLT, even though, of course, that provision. And if I may, my lord, could I come back to you after lunch on that point about directly or indirectly? I mean, it's certainly used elsewhere in the SDL code. And that is, I mean, ultimately, on the first argument, we're arguing about, it's the meaning of the word indirectly. That's what this case really turns on. Is it the procedure by which the money is transferred? Well, my learned friends actually about that, which means, of course, that actually no one these days pays anything directly. Everything is indirect because everyone pays by some form of bank or credit card. I won't get into an argument about whether cash notes are direct or indirect, given their promissory notes.
In my mind.
But I don't think many people these days pay their house deposits with a suitcase of cash. If they do, then their solicitors may have some questions to ask. So everyone is making indirect payments, apparently. Or whether it's meant to mean something a bit more substantive and is supposed to catch cases such as this, whereby the consideration under one contract, we are looking at the consideration under that contract, has been given indirectly by another person, we say, because it's been funded directly and solely for the purpose of paying that. Actually, I didn't mean to go into the argument that far, but I was actually going to come back to this document on that point. Because if we look at this document, the relevant parties are consciously and expressly stating that the funds that are going to be transferred or promised to the company are those which are to be used to purchase the property under what we are going to call the original contract. In particular, the letter states in the penultimate paragraph on page 157, once the company has been formed, you will use the deposit monies to subscribe for shares in it equal to the value of the deposit. It's express that the money being transferred to the company via the first share subscription, there will be two sort of, constitute the deposit, the consideration the company will use to acquire the property. It's their terminology. And at the end of that page, it stated that the shares subscribed for via a promissory note. I believe courts are aware it wasn't as if all the cash even went into the company's bank account. It's done via a promissory note. And it said that that second promissory note will be equal in value to the price to be paid for the property. So it's known that the funds subscribed by promissory note will align with the remainder of the consideration, the price. To my submission, price is a pseudonym for consideration. Under the original contract. And it was on the basis of that document, I'm coming to another critical finding, the first tier, which is paragraph 26, it found that the monies paid by Mr. and Mrs. Brown to the company, i.e. through the subscription, were given under a scheme in which plainly the deal was that those monies were the quid pro quo for the house. That's the finding of the tribunal. Unchallenged. So not a finding made without thought and consideration of how the parties intended this arrangement to operate and how they described it as operating. Now, of course, the deposit monies came from Mr. and Mrs. Brown's bank account to the company and then to the seller. That's the deposit. So directly, the consideration was paid by the company to the seller. Also, the remainder of the funds, which had been borrowed by Mr. and Mrs. Brown from a commercial lender to purchase the property, and on that point, just to make sure the court is clear, still in the supplementary bundle, it's actually the next tab, 162, page 162, 162 and 163.
This is them getting their mortgage.
Yes, because the party who borrowed the money was not the company.
Yeah.
It was Mr. and Mrs. Brown.
Yeah.
And they borrowed it. Obviously, when you borrow money for a mortgage, it's with a target property, to buy this property. And those funds went to Mr. and Mrs. Brown's solicitor, i.e. their agent, and then directly to the vendor. Never actually touched the company's bank account at all. Why do all those funds go via the company, to the extent they do? The reason is solely to achieve the tax avoidance objective. There's no other motive to any of this, no pretense of other motive. We don't need to worry about facts where there might be another potential motive. There's no point thinking about cases where maybe a company already has cash, or maybe has cash and it doesn't know what it's going to do with it, or doesn't know it might want to buy a property, doesn't know which property. Those aren't our facts. And that's the correct way to view these transactions, as they were intended to operate. That's very well established, and it's set out in Rossendale, which of course is the latest word. But just for your reference, that particular point is also addressed in Scottish Providence, paragraph 23. I'll just give the references where I made their sidelines, which is tab 12, page 150 of the authorities bundle, and Barclays Mercantile, paragraph 32, which is cited in Vardy, first tier Act 21. What's said there is simply, you don't need to look at whether the steps are sort of legally obliged to take place in that way. You look at how the plan was intended to operate, which is exactly what the tribunal did here correctly. And as the court will be aware, schemes of this nature have come before the first tier before. This is the first case where one of these particular schemes, using the company, have come up to the Upper Tribunal in the Court of Appeal. And the reasoning of the first tier in those cases, it's Vardy and Gearing in particular. I'm not going to take you to them because they take us no further than the Upper Tribunal. It's exactly the same though as the Upper Tribunal, i.e. in the context of a preordained tax avoidant transaction, the consideration under the original contract can properly be said to have been paid indirectly by the actual purchasers. That is now the universal analysis. So those are my comments on the facts. I'm now moving on to look at section 45 itself, which the court may have in a number of locations. In the authorities bundle, it's tab 2 page 9. So subsection 1 contains the qualifying conditions for section 45 to apply. There has to be a contract for land under which a transaction is to be completed by conveyance. So that's the original contract. I hope we're all using the same letters, but usually A, B, C is usually what's used. B is important. There is an assignment, subsale, or other transaction relating to the whole or part of the subject matter of the original contract, as a result of which a person other than the original purchaser becomes entitled to call for a conveyance to him. So that's C.
Yep.
And that wording is particularly important when we come to look at 3B2, because 3B2 refers to a transfer of rights, which is not defined, but is clearly a reference back to subsection 1B. That's the transfer of rights. And the wording of 1B is broad. In particular, it is not limited to contracts, and it's not limited to land transactions, which is my letter in board. That is a defined term. It refers to any other transaction. Subsection 1 sees an exception. We don't need to concern ourselves with that. Subsection 2 brings in the effect of section.
So just so that I'm catching up, subsection 1A is confined to a land transaction, but B doesn't have to be a land transaction.
Yes, my lord.
So you would say the subscription of the sales, of the shares, would be a
most certainly.
Yeah.
Yes, and that will come into the third analysis, which was the FTT's analysis, which is now our second backup point. When we come to look at that, we are certainly not confined to land transactions, and we're entitled to say, well, what transactions did take place and what was the consideration for them? So looking at subsection 2, that brings in the effect of section 44, which is a contract for a land transaction which is to be completed by conveyance is not treated as a land transaction until it's been substantially performed. My learned friend took you to that provision. So the original contract, provided all the conditions are met, is not itself a land transaction. Subsection 3 provides that section 44 applies, but to a deemed transaction, and there are three main deemings under subsection 3. Firstly, actually the tailpiece, which is that we disregard the substantial performance or completion of the original contract, the AB transaction. Secondly,
where are you reading from?
So the tailpiece of 3, it starts with the substantial performance, the tailpiece. So that's the disregard. That's the first deeming. We ignore the first the transaction which would have been completed by the original contract. Otherwise, you would have a double charge. Secondly, 3A provides the transaction is recharacterised as an acquisition by the ultimate transferee. So it's C acquiring from A, effectively. And then thirdly, what is the deemed consideration for that transaction? That's ascertained under B, which of course is the focus of the case for you today. And there are 3 categories of consideration which may be taken into account under 3B. The first one is B1, so much of the consideration under the original contract, as is referable to the subject matter of the transfer of rights. And it's common ground, of course, you've got an identity between the subject matter here. So we can effectively ignore that that requirement for the purposes of today. So it's so much of the consideration under the original contract as is given directly or indirectly by the transferee, i.e. C. That's the first category. Because HMRC submit that Parliament evidently wanted to draw that provision quite broadly because of the use of the word indirectly. That is not simply intended to cover payment mechanism. It means something more than that. The second category is consideration under the original contract given directly or indirectly by a person connected with the transferee. That's also under B1. That's a different category. And the third category is B2, which is the consideration for the transfer of rights. The transfer of rights, as I said, is a reference back to 1B. So we read the consideration for the assignment, subsale, or other transaction as a result of which the transferee becomes entitled to call for a conveyance to him. We read that in. We note B2 does not specify who has to give that consideration for it to fall within that provision. An HMRC submit in this case, the sums paid under this arrangement fall within at least one of these categories, particularly looking at the breadth of the wording. But to be clear, HMRC submit that even if consideration could fall within more than one of the categories, the same consideration will not be taken into account twice. There is no risk of double track taxation. That was a point pursued in particular before the Upper Tribunal, to which HMRC responded with a number of examples which were in the annex to my Upper Tribunal skeleton. There is no risk of double taxation. Moving now to apply section 45, I'll take each of the analyses in turn, starting with the analysis of the Upper Tribunal, which is also referred to as the Vardy analysis, because it was adopted by the first two, Vardy and Gearing, which was HMRC's primary argument, sole argument for the first two. I'm not here to pretend that there were other arguments being put forward. That was HMRC's argument, and I'll come back to that on the procedural issue. I know, friend, it's quite fair to say that was HMRC's submission. So the first step, looking at B1, not the connected party limb, but the giving directly or indirectly, the first step is to identify the consideration for the original contract. We know what that is. It's £955,000 in this case. No dispute about that. We're not looking at consideration for different transactions. We're looking at consideration for that land transaction under that contract. £955,000 cash. And then secondly, and this step's in brackets because we need to check there's an overlap between the subject matters. We know there is. So the only point in dispute is whether that consideration of £955,000, which was given directly by the company, can also be said, applying the ordinary purposive principles, to have been given indirectly by Mr. and Mrs. Brown under this arrangement. And in the context of a pre-planned tax avoidance scheme, where the sole reason that the funds were given by Mr. and Mrs. Brown to the company was so that the company could pay the consideration under that original contract, and there was no other reason for the contribution of funds, no dilution here of the purpose and intention of everyone involved, HMRC submit that the Upper Tribunal rightly found that the consideration can be said to have been given indirectly by Mr. and Mrs. Brown. As held by the Upper Tribunal, approving the decision in Vardy, the fact that funds, we're talking about subscription funds here, may be paid for one immediate or direct purpose, say the subscription of shares, does not exclude a conclusion that they are given indirectly for something else, here to pay the consideration under the contract with the actual vendor, under the original contract, on these facts. That was the entire objective of the scheme, that the funds to purchase the property would be paid indirectly via the company. And indeed, that's why I took you to that letter at the start. That conclusion, that what they were doing was indirectly giving the consideration to be paid under the original contract is entirely consistent with how those funds were described by the parties. In particular, they said the initial funds being subscribed, they described it as the deposit, the consideration which was going to be paid under the original contract. And to be clear, that is not some far-reaching or radical Ramsey recharacterization. That's simply adopting the uncontroversial approach of asking, looking in particular at these facts viewed realistically, the consideration under the original contract had actually been given indirectly by Mr. and Mrs. Brown. It's no more complicated than that. Indeed, this analysis respects the transactions because it accepts there are two transactions. That's why Section 45 applies. We've seen the Upper Tribunal was tempted to actually throw the whole transaction out and say, well, actually, we're going to look through all of this. It didn't do that, though, very importantly. It said we might have done this, but everyone accepts Section 45 applies, so we're not going to do that. They respected the transactions. All this analysis does is simply applying the provision. We need to identify whether on these facts, the funds that Mr. and Mrs. Brown were in fact were subscribing were being given indirectly to purchase the property, which they obviously were. That is currently the universal analysis of the courts on this scheme. One footnote, which is Judge Hellier's decision in the first here, which has been overturned. And of course, I'll come back to that on the third analysis. And that's a world away from any real-world commercial example. For example, involving a commercial lender or something like that. We don't need to worry about those examples. We're looking at these very particular arrangements. We don't need to recharacterize them. We just need to ask whether those funds were indirectly being given to pay the consideration. That's all. And given indirectly, giving that word a real meaning in the context of this legislation. And it is possible, in a real-world commercial transaction, it might not be possible to apply that analysis. It depends on the facts. Of course, it needs to be a real-world analysis, not where you've got a third-party lender, a bank. You've got to have someone who's actually buying, ultimately,
well,
the C who ends up with the property.
lender is not going to acquire the same property.
Exactly.
The third-party lender would acquire a security interest, which is exempt.
Exactly. You could only try and envisage, but I don't think we've really heard any examples of where this might fall apart in a real-world commercial example. It's not going to be a standard lender because it's got to be someone who ends up acquiring the property. Yeah. The only time that happens in lending is Islamic finance, which does have a specific provision for it. It's not going to happen with someone who all they're doing is lending money and then securing their loan. That's not treated as being an interest in respect to which SDLT is chargeable. And it's certainly, we don't need to worry about that sort of case, whereas a first-tier tribunal found as a fact that subscription was the quid pro quo of getting the property. Indeed, given that unchallenged finding of fact, it's difficult to see how there could be any other conclusion than saying, well, indirectly, Mr. and Mrs. Brown gave the consideration in respect of that contract.
So, ought to be looking at the clock as I was as well. On the
I could finish this point with the other statutory provisions, but
so
perhaps I should take
what would you prefer to do? You prefer to do that before we break or when we come back?
It might take me more than 2 minutes. My clock says 1 minute too, so if
so I think my computer says it's 1 minute. So well, shall we break now? And is 2 o'clock convenient? And come back at 2 o'clock. Thank you.
Cool. Why is it open?
the reality